So thank you so much, everyone, for joining us at tonight's event entitled Safety, Not Suspicion, Advocating for LGBTQI plus people seeking asylum in a changing legal landscape. My name is Zehrah. I'm an immigration, asylum and public law barrister at Garden Court Chambers. I'll be chairing the event, which is being co-hosted with Rainbow Migration, and we have an expert panel of speakers today from both organisations. I've also had the privilege to do some work with the brilliant team at Rainbow Migration as a consultant, so I can really attest to the amazing work that they do. I'm really grateful to all the speakers for their time today in their busy schedules. I imagine most people joining today will be familiar with the work of both Garden Court Chambers and Rainbow Migration. But just in case you haven't come across Rainbow Migration before, the organisation formerly called UK LGIG is a specialist charity which supports lesbian, gay, bisexual, trans, queer and intersex people through the asylum and immigration systems in the UK. The organisation does this through its twofold service delivery, its legal advice service, which provides free and confidential legal advice to LGBTQI plus people seeking asylum or seeking to make a partnership application, and their support service, which assists LGBTQI plus people to access safe housing and healthcare services, as well as providing practical and social support to improve their self-esteem and confidence and reduce isolation. Rainbow Migration also carries out campaigning, policy work and strategic litigation to improve the asylum and immigration systems for LGBTQI plus people, often informed by the evidence obtained through its frontline services. So in our event today, we'll be considering how the sea change in asylum law, policy and practice over recent years has meant that LGBTQI plus people have often sadly been at the sharpest end of this cruelty and uncertainty. Across the sector, we're seeing the many ways that successive governments have made it harder for LGBTQI plus people to prove their claims and to remain safe whilst doing so. From raising the standard of proof under the Nationality and Borders Act to worsening conditions in asylum accommodation, increased detention and removals, queer and trans people seeking sanctuary are facing mounting barriers and growing danger. We're frequently seeing our LGBTQI plus clients and service users encountering less safety and more suspicion, although they fear return to countries where they would face devastating state or societal violence. And sadly, this is all happening in a context where the majority of countries in the so-called Commonwealth that still criminalise LGBTQI plus people do so as a direct result of British colonialism. And these changes are also happening in a context where we're seeing a rise in the far right across the world, accompanied by a wave of attacks on LGBT rights and the fueling of hostility and violence towards queer and trans communities. We've devastatingly seen this in the UK with the recent UK Supreme Court judgment, which excludes trans people across the UK from accessing vital spaces, having a material impact on our trans and non-binary siblings' access to crucial facilities, activities and services, and in turn undermining their dignity and safety in public life. So in this event this evening, speakers from both Garden Court Chambers and Rainbow Migration will try to unpack how these recent legal and policy changes have disproportionately impacted LGBTQI plus people seeking asylum and how we can collectively challenge this. We'll explore some of the strategic legal responses we could take, support work that can be done, and policy interventions that can centre safety, justice and liberation. And we also want this event tonight to be an opportunity to consider how, from an interdisciplinary lens, by working together as legal practitioners, frontline workers, charities and activists, we can best provide meaningful advocacy and solidarity to LGBTQI plus people in the asylum system. We hope, therefore, through the event, whether you're a legal practitioner, a caseworker, a support worker, a campaigns expert, or an organizer, you will leave with a more comprehensive knowledge of the specific experiences and legal issues facing LGBTQI plus people in the asylum system, how to counter the plethora of additional challenges they face, and ultimately be better equipped to more effectively advocate for and work in solidarity with queer and trans people seeking asylum. And we know politically this is a vital issue because we've seen in just the last week how the current government is ramping up political hostility towards all migrants, refugees, and people seeking asylum in the UK. And so we know LGBTQI plus people will continue to face multiple and intersecting harms as a result. Without any further ado, I will pass on shortly to Ayesha Aziz, who is the Legal Service Manager at Rainbow Migration. Ayesha joined Rainbow Migration in March 2022. She's a practicing solicitor with over 9 years of post-qualification experience in immigration law. She is also qualified as a level 2 senior caseworker and supervisor. She has worked as a resettlement expert with the UNHCR in Egypt and Iran, and has also worked with European lawyers in Lesbos as a volunteer lawyer. Today, Ayesha is going to talk to us about the impact of the Nationality and Borders Act and the raised standard of proof on LGBT people seeking asylum and the need for them to prove their claims. So Ayesha, I'll pass on to you.
Hi, good evening, everyone. Thank you for joining this evening. Thank you, Zehrah, for the introduction. So I'm the Legal Service Manager at Rainbow Migration. At our legal services in Rainbow Migration, we provide legal advice and support, but unfortunately, we don't provide legal representation. So our service is up to the support and advice only. I would like to just today focus mainly on how the legislative change, in particular Nationality and Border Act 2022, raising the standard of proof, has disproportionately impacted the LGBTQI plus asylum claims. And I would like to also touch on how we as practitioners can strategically respond and prepare our clients' claims to mitigate the impact of the raised standard of proof. Now, Nationality and Border Act has brought a significant shift in the asylum law, especially in terms of the standard of proof. So if I could get the next slide, please. As most of you might be aware, if a claim is made before the 28th of June 2022, the old standard of proof applies to all parts of the claim, which is the reasonable degree of likelihood. However, since NAPA, now there is a two-stage test with a raised standard of proof for the first stage. So for the first stage, the standard is assessed whether a person's credibility and the fear of persecution on the balance of probabilities, namely, is more likely than not. This, of course, has had a clear impact on LGBTQI plus applicants, because now they would have to prove their sexual orientation and gender identity to this high standard of proof in an environment where we already are having a culture of disbelief. And then we've got the second stage test, which is to assess the risk of persecution and the availability of state protection to a lower standard, i.e., whether it is reasonably likely. Therefore, at the moment we're in a situation where sexual orientation and gender identity of a person seeking asylum is to prove on the balance of probability, which is much higher than previously. And therefore, consequently, this leads to the requirement of more evidence in order to prove your sexual orientation and gender identity. And therefore, even a more stringent assessment of the credibility and the consistency of people's accounts. Therefore, this fundamental shift is particularly challenging for those people who've never come out before publicly about their sexual orientation or gender identity, or has limited or no knowledge and understanding of how to prove their identity in Western terms, or those who does not fit the stereotypical image of what an LGBTQI people should behave, how they should behave, what they should look like. And even more difficult for those who've had to conceal their identity due to the fear of persecution, and then hence their only evidence is their own testimony. And most of the time, the worry that our service users have, that we face daily, is how do I prove my sexual orientation or gender identity? What evidence can I provide? So the most of the time people are worried, what shall I provide to prove my sexual orientation or gender identity? And they feel lost in this process. And there are so many intersecting reasons for LGBTQI people seeking asylum that they cannot provide the documentary evidence. And these are things that are included, their experiences of racism, access to services, including the mental health services, accommodation issues, affordability of basic necessities. And with all of this, issues that they face daily while they're going through the asylum process, they're having to prove their sexual orientation and gender identity. Now, how does one do that? Especially with so many myths and misconceptions around LGBTQI claims. For example, there's a myth around it's easy for people to pretend to be LGBTQI plus, and it happens all the time, and it's easier for them to get status. Whereas in reality, it's a very inhuman and degrading process to put someone through to prove their sexual orientation or gender identity. Or another misconception that if you come from a country where being a member of LGBTQI you're persecuted, you will get asylum. Again, this is not true, because they will have to conceal some or all elements of their sexual orientation or gender identity in order to avoid persecution. So one can only imagine how difficult it is to prove your sexual orientation and gender identity with this high standard of proof when someone has already made up their mind that you're lying and they don't believe you, and you're having to prove yourself to someone who's already think that you're lying. And this is what most of the applicants, most of our service users are going through right now in the asylum process. And it's even more traumatic for those who are survivors of violence and are vulnerable. So when the only evidence that someone has to prove their sexual orientation and gender identity is their own testimony, the entire assessment rests heavily on the credibility and inconsistency at the asylum interview or in the applicant's statement. And this assessment often includes subjective judgments, being penalized for inconsistencies, even when it's rooted in trauma, in shame, or fear. That's something the Home Office does not take into account. Or even delayed disclosure. Home Office, again, ignoring how trauma or homophobia or past abuse can impact one's openness. So these are the sort of issues that people are facing daily, having to prove in the high standard of proof their sexual orientation and gender identity. Can I have the next slide, please? Now, whilst there's a higher bar, but the road hasn't been easier for those to prove their sexual orientation and gender identity, because since NAPA, there is a noticeable uptick in refusals and high raise in appeals to the first-tier tribunal, which I think most practitioners would know it's actually clocking the system and overburdening the tribunal right now with so many appeals. And it seems more like the backlog from the Home Office has now shifted onto the tribunal because of the number of refusals. And while the standard of proof has risen, if anything, the applicants' needs right now is the support, access to legal representation, a fair process. But in reality, in our experience, they're receiving the opposite. And there are several obstacles that applicants are currently facing through the asylum process, trying to prove their sexual orientation. And few of those that come to our mind right now that we face daily is one, for example, the lack of quality legal aid lawyers. As a result of systematic underfunding, there are very few legal aid immigration providers left. And I've shared some links here, reports by Joe Wilding, where it's clear that finding that more than 50% of people seeking asylum does not have legal representation because the supply doesn't meet the demand. So therefore, finding a legal aid lawyer for applicants is not only time consuming, it's traumatic, it's stressful, and it's an exhausting process. Because for many of our service users, for example, they're facing rejection daily. They feel lost, they feel abandoned, and they don't know how the procedure works. They need advice, they need assistance, but they cannot get it, and they receive rejection every day from the legal aid suppliers. Another issue is the asylum interviews that we come across quite a lot. So as you all know, the substantive interviews are the crucial and the main part of the asylum process. And there is a high number of unrepresented applicants, which means that the only evidence that Home Office has to make a decision usually is just the asylum interview, the substantive interview. They don't have detailed statements or legal representations to furnish the claim. They don't have information structured for them in the legal representation to make a decision. And nowadays with concise interviews also, applicants are having to attend the second or the third interviews, or usually after the interviews they're issued with a number of questions to answer within a certain deadline. Again, even for those who don't speak English. This causes stress, confusion, and again, a self-isolate, completely isolated during the process. And unfortunately, we still come across several interview transcripts where inappropriate questions are asked about people's sexual orientation or gender identity. And this is becoming increasingly concerning for us. Badly conducted interviews lead to poor quality of decisions also. So we are having to receive decisions that are very poor quality. The high threshold combined with these issues has created a very unrealistic demand for someone to prove their sexual orientation or gender identity. And we've seen an increase in refusals, mainly based on credibility findings or failure to meet the standard of proof. But in the midst of all of this chaos, as we continue to support and advocate for a fair process, we as lawyers play a critical role. Because while we cannot change the law immediately about the standard of proof, we can play a part in preparing a stronger claim for our clients. And there are just a few recommendations and tips that I would like practitioners to keep in mind when conducting sexual orientation or gender identity cases. I get the next slide, please. So our first recommendation is, with such cases, please be proactive when gathering evidence at an early stage, because this can include, and this kind of evidence that you're trying to gather can include advice on for your clients to write their own personal story if they speak English, gather supporting letters and statements if possible, consult their doctors for medical reports if receiving treatment. Think widely about the type of evidence they can obtain, and where they can't provide evidence and cannot obtain it, give a full explanation as to why your client cannot obtain the evidence. And also, please do not hesitate to instruct country experts, because it can be very valuable part of the claim. Experts can contextualize delayed disclosures, challenge harmful stereotypical findings in a refusal letter, rebut the Home Office's position about the risk of return with someone of your client's profile. So it can be very valuable to the client's claim. And please ensure that your clients are thoroughly prepared for the substantive interview, as credibility remains a major reason for asylum refusals. Help your client to anticipate an inappropriate or deeply personal questions. Explain the importance of inconsistencies and credibility issues. Explain their rights during the interviews, issues with interpreters, which we're seeing quite a lot with our service users during the interviews. And it's important that because a poor interview, especially, can lead to credibility finding, which can be very damaging. So preparation really helps to express themselves confidently, and even if they're under pressure. And please thoroughly consider merits for judicial review in cases where claims are being certified. I know Helen will go into this in more detail later, but Home Office tend to certify cases from safe countries, for example, India and Georgia, which are actually unsafe for LGBTQI plus people. So please thoroughly assess those claims, because an early preparation can be crucial and make it difficult for the Home Office to refuse the claim. In our experience, also in our opinion, we think that all these cases should be billed as escape fee, because they cannot be limited to fixed fee. And in refusal and appeal cases, please instruct your counsel in advance. Seek their expert opinion, their guidance, discuss the case at an early stage of the appeal process. And then hopefully all this preparation and gathering of evidence can be helpful to meet the higher standard of proof. And I've just included in the next slide some links that you might find helpful. And I'm happy to take any questions later. So thank you all very much.
Brilliant. Thank you so much, Ayesha, for that really comprehensive outline of the changes under the Nationality and Borders Act and how we can try and mitigate them. I think it's so important to not take anything for granted now and to really make sure these cases are thoroughly prepared. And all those tips are extremely, extremely helpful for both initial claims and appeal stage. I'm going to now pass on to Karen. So Karen is a trainee solicitor and Justice First Fellow in partnership with Rainbow Migration. And she works at Wilson's Solicitors. Prior to joining Wilson, she spent 27 years as a migrants' rights and anti-racist activist before deciding to retrain as a solicitor. She gained substantial experience working with LGBT asylum seekers and people in immigration detention, and in particular, those subject to deportation on charter flights. So Karen today is going to provide us with an overview of some of the recent case law in this area, in both the domestic courts and in the European Court of Human Rights. And so something really important to also consider when preparing claims, in addition to all the evidential issues that Ayesha mentioned. So Karen, I'll pass over to you now.
Thank you very much. So I'm going to start with HJ Iran, which I'm sure that most people on this webinar will be familiar with, but it's important to look at this when considering a recent Strasbourg case, MI Switzerland. And then I'm going to look at an even more recent case in the Court of Appeal, PG, SSHD and PG, which concerned a Sri Lankan gay man. And it highlights a key tension between the UK courts and Strasbourg in relation to country guidance cases. So HJ Iran is the key case when assessing particularly LGB asylum claims, and it established a four-part test. And prior to HJ Iran, people were told you can go back to your country, live discreetly, and you won't come to the attention of the authorities. It didn't matter if there was persecution. HJ Iran introduced this four-part test, which did affirm that you can't tell someone to go home and be discreet, that is persecution. But it introduced a new kind of conundrum for people working with LGBT asylum seekers. So the four questions are, is it reasonably likely that the person is gay or LGBTQ, or will they be perceived to be gay or LGBTQ? Is there a real risk in that country that this person could face persecution because they are LGBTQ? And then these two last questions, would the person live openly or would they conceal their sexual orientation? And the final one, if they would conceal, why would they do so? These last two parts of the test are the problematic core of HJ Iran, which essentially introduced a new discretion test. And what that did was it place a heavy burden of proof on claimants to explain their future behavior and internal motivations, something that is extremely difficult, especially for those who've been traumatized by a lifetime of trying to survive in an extremely hostile environment. But to be honest, for any of us, even in the UK, if we are asked why we make the decisions we do about whether we're out all the time or we're out to certain people or we keep our sexuality at home, it can be a really hard thing to express or explain the motivations behind why we make that decision, being LGBT is not a state of permanently being open about your sexuality. We don't wear "I'm gay" t-shirts all the time. And the closet is not one door, it's multiple doors that we have to open over our entire lifetime. Now that's really complex, right? That's incredibly complex. And then when you ask an asylum seeker who's been having to hide those parts of who they are and is not part of a wider discourse or a wider community where these things are discussed and debated and developed, it's an impossible ask. It can create a real space for cultural stereotyping in decision making when an applicant doesn't fit Western assumptions about LGBTQ expression, risking them being disbelieved. So the test focuses too much on a hypothetical future conduct based on where someone's headspace is at right at that time, rather than the actual risks to LGBTQ people in their country of origin. So in other words, it's a fallacy. It's a logical fallacy. Someone could decide purely out of personal preference, and I still find that problematic, that they will not live openly. HJ Iran would say that that person could be sent back to a country where potentially they face persecution. But the reality is, if you send that person back, even if they try really hard to hide who they are, the risk of discovery exists. And if you are discovered, you will be subject to brutality, torture, arrest, psychological abuse, a whole host of persecution. So that's the fallacy of this new discretion test. And I'm happy to say, if we go on to the next slide, that the case of MI Switzerland, which was a European Court of Human Rights decision last year, November last year, really rejects that. It explores thoroughly that fallacy, and it rejects the idea that concealment could ever protect an LGBTQ asylum seeker. So in MI Switzerland, the applicant was a gay Iranian man facing expulsion, and the Swiss authorities argued that he wouldn't be at risk if he lived discreetly. The court said, no, Article 3 is absolute. It doesn't matter whether the applicant is currently known as gay. What matters is that if they are discovered, they could face ill treatment. And the court found that Switzerland failed to assess whether Iran would protect him from harm, especially by non-state actors. So this judgment firmly reasserts that expecting discretion to protect someone from persecution is unlawful, whether that discretion is based on fear or not. It's a really great decision, and I would recommend that people read it. We do have to remember that European Court of Human Rights judgments under Section 2 of the Human Rights Act, they are not binding. So UK courts aren't bound by this decision. It does not, there is not a duty to follow Strasbourg judgments. However, there is a duty for the UK courts to take Strasbourg decisions into account, particularly where those decisions are clear and consistent. So MI Switzerland is a strong and persuasive authority. It carries significant weight. And I think if you have a client, if you are working with someone who does express that they would hide who they are because of social or cultural or religious reasons and not out of fear, then it is really important that you are bringing MI Switzerland to the table, that you're making that argument, because we do need to get this tested in the UK courts. So I think it's worth making in every case. If we can go to the next slide. This is an even more recent decision in 2025, SSHD and PG. And this is a Court of Appeal decision. So PG is a gay Sri Lankan man facing deportation after serving a prison sentence, arguing that he'd faced persecution as a gay man in Sri Lanka. The first-tier tribunal agreed with the strong evidence presented that there were worsening conditions for LGBTQ people than the previous country guidance cases, LH and IP, gay men risk. So just so people are aware, in UK courts, there are a number of country guidance cases, and these are cases that establish very set rules and law about how particular cases from particular countries should be treated. And there are very strict prescriptions about when those country guidance cases can be departed from. And it's first tier, it's always going to be an upper tribunal that has to, that departs from country guidance cases. The upper tribunal at first set aside the first tier tribunal decision, but on rehearing the case again, they again allowed PG's appeal, expressing doubts about the reliability of the country guidance. SSHD, the Home Office, appealed get to the Court of Appeal. And the Court of Appeal overturned the upper tribunal decision, saying that the upper tribunal failed to properly justify departing from the existing country guidance cases. It insisted that any departure must be supported by detailed, compelling new evidence, something that the judges in the first tier tribunal and the upper tribunal clearly felt they had. This shows how UK courts prioritize procedural discipline over real-time human rights developments, even when credible evidence suggests that country guidance may be outdated. So this is MI and PG, peaks and troughs. These two cases reveal a tension. MI encourages a flexible, fact-sensitive approach, acknowledging evolving risks. PG reinforces the UK's rigid adherence to established guidance, even when events on the ground can shift rapidly. This is not a surprising conflict. It's something I'm sure a lot of us have come up against. In asylum cases, the pace of country guidance often lags behind political and human rights developments. And that's not limited to LGBTQ asylum claims. However, as Zehrah was saying, given the global rise of the far right and the ways in which LGBTQ rights are often used as a political football, country conditions for issues such as LGBT rights can be more changeable in a hostile climate. I've done a number of Namibian cases, appeal cases recently, and over the course of a year of working on one case, there were 4 or 5 new developments in the country where the courts are bringing in more progressive, making progressive decisions, but the government are consistently challenging those decisions and bringing in new laws to overrule those decisions. So things move fast. If we can move to the next slide. So this slide here just summarizes that conflict. Country guidance system in the UK, it does provide consistency, but it shouldn't override our obligations under the European Convention. So MI reminds us that Article 3 protections are absolute. They are not subject to discretion or balancing, whereas PG shows the risk of procedural rigidity during these protections. We need a system that evolves and can move quickly, and these country guidance cases can stop that from happening. Final slide. So thank you for listening. It's a very short and whistle-stop tour of some of the recent case law, and later I'm happy to answer any questions. Thank you.
Thanks, Karen, for that brilliant summary, and yeah, really being able to tease out those contradictions in a short amount of time, really invaluable insight. And I think really highlights the importance of understanding the country context of the person that you're working with, and the risks that they would face in that particular country. And I think that leads on quite nicely to our next topic as well. And I will be passing on shortly to Helen, who is a barrister at Garden Court Chambers as well. Helen specialises in immigration, judicial review, human rights and nationality law. Her expertise encompasses civil litigation arising from unlawful detention and SIAC appeals involving national security issues. Helen has 15 years experience in the first tier and upper tribunal and the administrative court. She's appeared in the Court of Appeal and Supreme Court, where she's been junior counsel in the cases of KO Nigeria and R. Haisaj and others. She specialises in complex protection claims on behalf of trafficking victims, children, LGBTQI+ refugees, and those fleeing gender-specific persecution. And during her legal training, she had previously volunteered for UK LGIG, which is now Rainbow Migration. So Helen is going to talk about safe state designations, which impact LGBTQI+ people seeking asylum. So mainly the certification regime that's currently in force, but also the potential introduction of automatic inadmissibility decisions under the Illegal Migration Act. So Helen, I will pass on to you.
Thank you very much indeed, Zehrah. So as introduced by Zehrah, I'm going to look at two aspects of the statutory regime which have a particular impact on LGBTQI people, insofar as they relate to the idea of state or safe country. The first of those is already in force, will be familiar to many of you here. That is the certification provisions whereby a protection claim can be certified as clearly unfounded under the 2002 Act, which we'll look at in a moment. And the second, perhaps even more pernicious development comes under the Illegal Migration Act 2023, not yet in force, but on the statute book and ready to go should this or a future government want to bring it into force. So if we could have the next slide, please. This is an overview of Section 94 of the 2002 Act, which many of you will be familiar with. Section 94(1) provides a general power for the Secretary of State to certify an asylum claim or a human rights claim as clearly unfounded. So that is a broad discretion which could apply, for example, in a case where the claim just doesn't meet the definition of an asylum claim. For example, if someone were to theoretically claim that they didn't have a well-founded fear of persecution. So depending on the case, the Secretary of State may be able to apply that power to it. But what we're really interested in here this evening is the power under Section 94(3), which applies where an individual who makes a claim is entitled to reside in one of a list of so-called safe countries, normally where the claimant is a national of that country. And there is a list, so we'll come to the list in a moment. So what Section 94(3) says is that the Secretary of State is obliged to certify such a claim as clearly unfounded unless satisfied that it is not. So where an individual makes a claim and the individual is entitled to reside in one of the so-called safe countries, depending on how much evidence and information the Secretary of State has, and we can talk about that in a moment, it won't necessarily be certified, but there is a statutory presumption of certification where the claimant is from one of those countries. So just looking at the next slide. The current list is there on the slide. It's sometimes called the white list It's in subsection 4. It includes countries which many of you will have clients from, for example, Albania, Jamaica, Nigeria, Gambia. So that's the current full list of countries. You'll see that some of the countries are included only in respect of men. The list is periodically amended, so the original list was much smaller than that. I can't remember, I'm afraid, when it was last amended, but there's a power for the Secretary of State to add a country to the list. If we could have the next slide, please, where the conditions in section 94(5) apply. I won't read that out, you've got it on the slide. But the conditions are that either there's no serious risk of persecution for persons in that state or part of the state, or alternatively, the Human Rights Convention equivalent of that, where there won't in general be a contravention of the UK's obligations under the Human Rights Convention in the event of removal. So that's the white list of states. I'm just moving on to the next slide, please. An issue we may want to discuss later in the Q&A, and I'd be very interested in people's experiences of this, but I'm told by colleagues and other speakers this evening that there's been a noticeable rise in the number of cases from LGBTQI individuals from Brazil who've seen their claims being certified, often in circumstances where they're detained, again, which we'll look at later. Other common certification cases include Jamaica, Nigeria, Ghana, and India. And as you'll probably be aware, some of those countries have been subject to targeting for increased forced removals, including Nigeria and Ghana. There's also a link there in the slide to an article about Brazil. And those cases, or cases that involve certification, will often be quite urgent cases, perhaps because a client's been detained and issued with removal directions. And it may be necessary, and it often is necessary, typically, to issue an urgent judicial review, challenging not only the certification decision, so the overall decision, but in many circumstances, detention and removal directions, where removal directions have been set. The consequences of certification, again, as many of you know, are very serious in terms of how to challenge them, because, or in terms of litigation, because there's no right of appeal. One of the most common remedies in terms of litigation and going to court is, of course, well, the only court remedy, of course, is judicial review. Again, just a reminder, many of you will already be familiar with this, but in case not, here's a summary. Happily, the threshold for successfully challenging a decision to certify a claim is relatively low, because a claim can only be clearly unfounded if it can't succeed, quotes, on any legitimate view of the facts or the law. So a high threshold for the Secretary of State to have to certify a claim, or to have to meet in order to lawfully certify a claim, and a relatively easy test to meet for the claimant. The leading case is ZT Kosovo, and I've given you the reference for that there in the slide. Just going over to the next slide, please. There's a longer quote, just summarising the legal test. A claim will either be clearly unfounded, or it won't be. And another useful reminder, just moving on to the next slide, is that the test is an objective one. There we go. So even though we're in judicial review territory, the court is to ask itself whether on the material before the Secretary of State, the claim is clearly unfounded or it isn't. So that's the legal test in judicial review. Just moving on to the next slide, please. It may be that a client has not yet, for very good and understandable reasons, had an opportunity to put forward a claim based on their sexual orientation or gender identity at all. Perhaps they've not yet had access to a skilled or empathetic lawyer. Perhaps they are not yet in a position to feel safe enough to disclose an account of past mistreatment or to disclose their sexual orientation or gender identity. So depending on the circumstances, it may be more pragmatic to put in further submissions amounting to a fresh claim. Of course, if someone's got removal directions set and they're in detention, there'll probably need to be a judicial review anyway. But just going back to some of the issues helpfully raised by Ayesha earlier, it will be vital in these cases to obtain country background evidence, whether that's evidence in the public domain or whether it's expert evidence, to show that the country in question is not safe for the person concerned, for LGBTQI people. It will also be important, of course, to carefully obtain detailed witnessed evidence when the person feels able to do that, and where relevant, medico-legal evidence. So often a good strategy to put in further submissions, more and better evidence depending on the circumstances. Next slide, please. So that was a summary of certification under the 2002 Act. On the horizon, in the sense that it may be brought into force, is Section 59 of the Illegal Migration Act 2023. And what that does, without getting bogged down in the statutory provisions there on the slide, is essentially to add a new list of safe countries, or it provides the power to add a list of countries from which an asylum claim will be inadmissible unless there are exceptional circumstances. So as many of you know, currently Section 80A of the 2002 Act provides that if a claim is made by a national of an EU member state, unless the circumstances are exceptional, that claim will be inadmissible, which means, just moving forward to the next slide, it's an even bleaker scenario than certification is clearly unfounded. Just looking at the next slide, where the claim is inadmissible, there isn't any substantive consideration of the asylum or human rights claim at all. There's no right of appeal, and it's a JR again. So I've previously encountered in inadmissible cases on behalf of EU nationals previously. Moving on to the next slide. So Section 59, as I said, isn't yet in force, but it is in force for the purpose of making regulations which enable countries to be added to the list. And those regulations there, the 2024 regulations, have already added to the list, not yet in force, but the list is India and Georgia. And as we know very well, and just moving quickly forward, please, because I'm aware we don't have much time left, to the next two slides. There's already plenty of information in the public domain showing that India and Georgia are certainly by no means safe for LGBTQI people. And for reference there, on the last slide, Rainbow Migration and ILPA have done a very useful briefing which challenges this new piece of legislation with some very helpful case studies and more evidence about India and Georgia. So that's the 2023 Act. Thank you very much indeed.
Thank you so much, Helen. Obviously, some really concerning trends and possible further legal changes on the horizon, but I think hopefully a really good overview of how we can continue to challenge those as well. I should say that with the Brazil cases that we've seen, some of them have been conceded at pre-action stage as well. Sometimes the Home Office is issuing decisions that don't even consider their own country policy information note on Brazil, which is equivocal about the safety of it for LGBTQI plus people. So it's always worth putting in really strong reps at the pre-action stage, so that can be of assistance as well. So I'm going to pass on to myself now, and I'm going to talk about representing LGBTQI plus people in immigration detention, some legal strategies and potential policy change. Obviously leading on from what Helen has set out, something we are dealing with more and more as more people's claims are being certified and they're being detained as a result. Next slide, please. So, of course, it goes without saying that immigration detention itself is a cruel and oppressive system which causes all people subjected to it immeasurable harm. But it's important to note that there are specific impacts that have been documented on LGBTQI plus people, which I'm sure a lot of you will be familiar with, but it's worth bearing in mind the specific things to look out for. People who are queer and trans in detention are more likely to face discrimination and harassment from other people in detention, but also detention centre staff, especially those who are open or who are perceived as being LGBTQI plus as others. Many people therefore try to hide their sexual orientation or gender identity whilst in detention, which is not only, of course, undignified for the individual, but causes then additional barriers to them evidencing protection claims based on their sexual orientation or gender identity because of their fear of disclosing it whilst they're in that environment. There are also threats of violence, and this is particularly a problem for trans people in detention, but many LGBTQI plus people face physical assault, sexual violence, and abuse. There is also a systemic issue in staff in detention centres lacking an understanding of LGBT issues and displaying themselves discriminatory and hostile attitudes towards LGBTQI plus people in detention. So people often don't have any recourse to seeking safety or protection from the abuse whilst they're detained. LGBTQI plus people often cannot fairly pursue their legal claims whilst they're detained. It's obviously harder to access lawyers from detention, but also, as I mentioned, harder to collect evidence to prove their sexual orientation or gender identity. So, as Ayesha had mentioned earlier, with the raised standard of proof, this evidence is more and more important when cases are particularly dependent on credibility issues. But if someone needs evidence that they are open or that they have that they're part of an LGBT community in the UK, if they're detained, particularly for a long period of time, how are they going to join support groups? How are they going to attend events? How will they form relationships with other LGBTQI plus people in the UK? So in many ways, they're almost set up to fail because they can't provide any of that external evidence. There's, of course, the devastating impact on people's mental health. With LGBTQI plus people in detention, depression, self-harm, and suicide attempts are common. And it's also a very re-traumatizing experience for people who may have been detained and persecuted by the state for being LGBT in their country of origin. And there's also the fact that medical treatment fails to meet the particular needs of LGBT people in detention. There's a lack of experience and discriminatory attitudes from healthcare staff. So people feel like they cannot speak openly about their health concerns. And detention centres are particularly ill-equipped to respond to the specific needs of trans people, which of course impacts their mental and physical well-being. And even after release, people can face difficulties in settling back into the community after negative experiences in detention. They may feel they don't have the mental capacity to access services or LGBT support groups. And so they miss out on that support, but then they also miss out on aspects of their evidential parts of an asylum claim. Next slide, please. So in the interest of time, I'm not going to go through all the recent changes to immigration detention law and policy. Garden Court Chambers did put on an excellent event earlier this year, which provided a comprehensive update on detention law. And I've included the link to that event in my slide. But as a whistle-stop summary, I'll just make 3 key points. The first is that we have seen the Illegal Migration Act attempt to make wide-ranging changes to immigration detention, but many of those provisions are not in force. So the Hardeal-Singh principles, which I'm sure all of you will be familiar with, still apply, but Section 12 of the Illegal Migration Act, which is in force, attempts to recast the 3rd and 4th principles, essentially by providing that what is a reasonable period will be, considered in respect of the opinion of the Secretary of State as to what's reasonably necessary. So this is an attempt to reverse the position in the case of RA from 2007, where essentially the Court of Appeal held that the feature of the Hardeal-Singh principles is that the court makes its own decision on what's reasonable. And the Illegal Migration Act attempts to recast that into what is essentially the opinion of the Secretary of State as to what's reasonably necessary. Notwithstanding that, it is arguable that the court's role as the primary decision maker remains with respect to compliance with Article 5 of the European Convention on Human Rights, the court's jurisdiction, of course, to consider implied statutory conditions for lawful detention pursuant to the Hardeal-Singh principles, and the reasonableness of the Secretary of State's decision. The second change is that there has been a significant watering down of the adults at risk policy and guidance. That happened in May last year. Essentially, the amended policy removes the policy intention which was created following the Shaw Review to lead to the reduction of the number of vulnerable people in detention and the reduction in the duration of detention before removal. And whereas before there was a clear presumption detention will not be appropriate if a person was considered to be at risk of harm, it's now a general presumption of liberty, which is strengthened for those considered vulnerable. And there are also quite significant changes which are relevant to people who are victims of torture and the second opinion policy regarding medico-legal evidence. And some of you may have been following the medical justice litigation on that and the changes to the adults at risk policy as a result. All of these changes, of course, impact LGBTQI plus people in detention, but it is important to note that the adults at risk policy does recognise that trans and intersex people remain recognised as an at-risk group. However, the recent changes to the adults at risk policy, despite lots of campaigning and advocacy efforts to do so, hasn't included lesbian, gay, bisexual and queer people as an at-risk group. However, the equality impact assessment, which accompanied that amended guidance, does say that LGBTQ plus people may be more likely to be victims of bullying and therefore adversely affected by their experience of detention. So that is something that can be relied on in the context of whether your individual client could be considered vulnerable. It's also clear that there's, of course, been an increase in the use of detention and the length of detention. So that's all going to impact the likelihood that an LGBTQI plus person is vulnerable to harm for that period. And Rainbow Migration did reveal from a Freedom of Information request that the number of LGBTQ plus people in detention increased by almost 50% from 2022 to 2023. The third point with respect to changes is the plan to expand the detention estate. And I've included a link here to some a really helpful overview that Corporate Watch did on the current plans to reopen old detention centres with private construction companies making millions of pounds of profit to do so, and former RAF bases being considered as detention sites with potentially over 1,000-person capacity. So it's important to understand that context as to why some of these changes are being brought into force. They're all being brought into force in tandem. The attempts to restrict the legal and policy frameworks governing immigration detention hand in hand with an expansion of the detention estate. Next slide, please. So what are some of the key things we can do to try and secure LGBTQI+ people's release from detention? Well, the first issue is, of course, making sure they can access legal advice and representation in the first place. There is, of course, a dearth of access to legal support for people in detention. Bail for Immigration Detainees' most recent legal advice survey, which was published in March this year, found that 58% of people surveyed didn't have an immigration lawyer. So remember that if you are a legal practitioner, if you are encountering someone in immigration detention, this might be the first time they're accessing any legal advice and support, and it may be the first time they have an opportunity to disclose their sexual orientation or gender identity to someone. So consider any indicators in what they say to you, even if they don't make an explicit disclosure, as to whether they could be LGBTQI+. And of course, that could go on to impact other aspects of their case, for example, if they have a valid protection claim. The second thing to, of course, then consider is the appropriate avenue of challenge. So at this point, are you considering an immigration bail application in the first tier tribunal, or would you be issuing judicial review proceedings against unlawful detention? Of course, be mindful that bail is often considered an alternative remedy if there are no questions of legality to be resolved that need to be dealt with by the High Court. But if you have an urgent case where there are removal directions, there's a case, for example, in the circumstances Helen was describing, where there's a certification decision, perhaps where bail has been refused previously, or conditional bail has been granted, but there have been delays to someone's release, then make sure you are considering the merits of an unlawful detention judicial review. But in either case, the broader principles will apply. And there are just 2 points I wish to raise around LGBTQI+ specific arguments that can be helpful. So when you're arguing as to whether removal can be effected in a reasonable period or whether removal is imminent, of course, you need to understand whether someone has a pending asylum claim or any other pending application. But in the context of LGBTQI+ people seeking asylum, you'll want to consider what stage they're at, and if they are refused, whether their case is likely to attract a right of appeal, or if it's certified, whether it's likely to be challengeable by way of judicial review. If so, that obviously indicates removal is not imminent or cannot be effected in a reasonable period of time. And I would say that this often applies to LGBTQI+ claims because they're often complex issues to explore. With certification, as has been set out, there are lots of reasons why a country may not be safe, so why their claim would not be clearly unfounded. And I think a real-world analysis is really important when addressing this. For example, the most recent statistics from the first tier tribunal published in March this year show that the mean time to clear an asylum appeal in the tribunal at the moment is 48 weeks. So sometimes we do see the Home Office saying, removal can be effected in an arbitrary period of time because all of these processes can be completed and then we'll remove the person. Obviously, that cannot be tenable. If someone has a right of appeal, they cannot prejudge the outcome, but also these processes are taking a very long period of time. So they will take a long period of time to resolve. And the second point is considering reasonableness in all the circumstances and the risk of harm caused to someone in immigration detention if they are LGBT. So as I said, the adults at risk policy is a really important starting point because trans and intersex people are expressly recognised as at-risk groups. And whilst lesbian, gay, bisexual and queer people are not, the policy itself makes clear that it's not an exhaustive list. And the equality impact assessment does also suggest that people with PTSD and victims of sexual violence or gender-based violence could also be found to be vulnerable by virtue of experience of harm relating to their sexual orientation. So make sure that you are taking instructions on whether someone has reported abuse or harassment in detention, if they have medical evidence of a deterioration in their mental health as a result, or evidence of them making a complaint. Can you get medical expert evidence confirming the same? And also, are they receiving adequate healthcare? For example, are they receiving gender-affirming treatment if they're trans or non-binary? Are they receiving adequate treatment for HIV if they have that condition? Also, you can mitigate against any risk of absconding by referring to, for example, support that person might have in the community. Do they have an LGBT partner or friends in the community who will support them on release? Have they previously attended an LGBT support group or have a support worker which they would resume contact with on release? And of course, do they have a legal representative for their case? What stage is their case at? And why would they have good reasons to keep in contact with the authorities? And I'll include on my last slide some reports from Rainbow Migration that can also be useful in evidencing the very wide impact of detention on LGBT people. I'm running out of time, but just to reference at the end of that slide, I've made clear that there are issues in terms of asylum accommodation and grace periods. So where someone is seeking release from detention, but they are waiting for a grant of Section 95 or Section 4 accommodation. Of course, it can be very difficult to secure their release without resorting to judicial review. But I've just highlighted some of the considerations around grace periods and the key cases there. But in particular, I would just say that, of course, some asylum accommodation is not suitable for LGBT people, but it can be difficult when you want to prioritise their release to be making those arguments concurrently because it could delay their release from detention. But do think about how you could front load applications for asylum support with any arguments about what would be suitable. And do also consider any issues with regards to delay. And I've highlighted at the end of that slide as well, a note in terms of Section 13 of the Illegal Migration Act, which is not yet in force, but if it were, it would essentially remove judicial oversight for the first 28 days of detention. So it's, of course, that would be devastating for everyone in detention, but it would leave LGBT people without recourse as well. And given the specific harms I've mentioned, it would be devastating, but we will see whether that is something that does get passed into legislation. Next slide, please. I just wanted to reference briefly some things that could be on the horizon. I mentioned at the start the Supreme Court ruling in the For Women Scotland and Scottish Ministers case. That currently impacts trans people's access to workplaces, public services, sporting bodies, schools and associations. But we could see a chilling effect in terms of other policy change. We have seen, by analogy, changes to the British Transport Police's policy, which now means that male police officers can strip search trans women. So we are mindful of the fact that there could be changes brought in that could affect trans people in detention. But the current approach is highlighted in the Home Office's guidance, the care and management of trans individuals in the immigration removal estate. That is interim guidance following the withdrawal of the detention services order in November 2024. But in essence, it does make clear that every trans person has the right to be treated with respect and have their preference considered once they are detained as to whether they're in a male or female detention centre, that they need to have a vulnerable adult care plan opened, and that an assessment has to take place in terms of the risk factors and whether they should be in a separate area in their affirmed gender, and they will have to consider whether someone has a gender recognition certificate, how long they've been living in their affirmed gender, and if they're receiving any gender affirming care. The final point I wanted to raise about what could come is Rainbow Migration has also been campaigning for changes to the adults at risk policy, importantly to include all LGBTQI plus people as an at-risk group, and to remove the evidence levels, which essentially gatekeep safety from detention for those who can and cannot access professional support. And so that there should be an inquiry that's triggered by mere self-declaration that someone is LGBT or in an at-risk group. And of course, to restore the previous policy position that was changed by the most recent update. I would highlight as well that there is a detention services order for LGB detained individuals. This is going to be reviewed in July 2025. But it does recognise that LGB people could be at risk of bullying. It provides that detention staff should be facilitating people to disclose their sexual orientation in a discreet manner, should they wish to do so. That homophobia shouldn't be tolerated, and indeed that measures should be taken to monitor homophobia, and people should be able to complain about mistreatment in detention. We know it's very rare in practice that the Home Office follows this detention services order, but people representing LGBT people in detention or supporting them could refer to that detention services order when you're advocating for people in detention who are being mistreated. But of course, you may want to prioritise securing their release. Next slide, please. So I've just finally included some useful resources, most of which are from Rainbow Migration. And I just highlight Rainbow Migration's campaign, No Pride in Detention, to end detention for all LGBTQI plus people. And just mentioning as well a story from a lesbian woman who was in detention, who Rainbow Migration supported, as a really stark reminder of the devastating experiences people face in detention and how important good representation is to ensure they can be released back into the community. Thank you. So I will now finally pass on to Ro, who is a casework coordinator at Rainbow Migration, who works with LGBTQI plus asylum seekers experiencing complex casework issues around a broad range of areas, including health, housing, and asylum. They have a particular specialisation in supporting trans asylum seekers, who often present a high level of vulnerability and support needs for both accommodation and healthcare advocacy. And alongside their work at Rainbow Migration, they also hold a part-time role as a caseworker for Big Leaf Foundation, which provides community projects and casework support to displaced young people in Surrey. And before these roles, they worked as a children's advisor with the Refugee Council in Kent, and they have extensive fieldwork experience in both Greece and France. So I'm going to pass on to Ro to speak about advocating for LGBT people in asylum accommodation.
Lovely. Thank you very much, Zehrah. This is a training that I usually provide for people at a casework level who maybe have a casework service supporting people in home office accommodation, but not particular experience with LGBTQI plus asylum seekers. It's adapted slightly as I'm conscious that we're going to have a higher number of legal practitioners and less caseworkers in our audience today. If you are from a casework service and you would prefer a more in-depth discussion of supporting LGBTQI plus individuals specifically, do get in contact. We run this training relatively frequently. And so if that would be beneficial to your service, please do let me know. I'm also conscious you've been listening to us for a very long time, so I'm going to try and run through this as fast as possible and hopefully end on a semi-positive note, which is a difficult thing to do in general in 2025 in this job. So we've talked about this quite a lot, and this isn't going to differ from anything that anyone else has discussed already. But I just want to run through some of the common problems for LGBTQI plus individuals in home office accommodation. There is a very high instances of abuse, harassment, violence, and or sexual assault for queer people in asylum in general. We don't have specific stats on whether this is higher than the general population. However, anecdotally, it would definitely seem to be the case. A part of that is the influence of accommodation location and demographic, and how that can affect the isolation of LGBTQI plus individuals in accommodation, whether that's the other residents of the accommodation or the people in the local community. A lack of ability to have a support network, whether that's friends or NGOs, community groups, really increases people's vulnerability to the types of harassment that are common for all people in home office accommodation. This is particularly true in accommodation where there is an expectation of room sharing, or there are particular shared facilities where queer or trans individuals might stand out in particular and be particular targets for harassment as a result of that close proximity. Similarly to Zehrah's point on issues with staff and detention, accommodation staff are not much better. We come across a lot of problems where hostility from accommodation staff results in people suffering abuse and harassment but not reporting it, where otherwise they might have felt comfortable to. And we also see an upsettingly high rate of accommodation staff themselves engaging in abusive behavior, harassment, or in many cases, treatment of LGBTQ asylum seekers that might out them and therefore increase their risk in accommodation. So people's willingness to report and document abuses they're suffering in accommodation is really low in this demographic. I discussed it a little bit earlier, but the isolation from community support comes in two factors. Where there is support for displaced people in an area, an LGBTQI plus asylum seeker might not feel comfortable being out and open in that space where they're going to be surrounded by their peers and potentially the people that they live with in their accommodation, as that might impact their safety. And where there is support for LGBTQI plus people, that might not be relevant or safe for someone with an unstable immigration status or someone who might feel uncomfortable disclosing their status as an asylum seeker. The other one, just to mention as well, is a lack of access to specialized healthcare services. So whether that's support for HIV positive individuals or support for trans individuals who are pursuing some aspect of medical transition. I'm going to touch a little bit more on this later, but specifically when referring to trans healthcare support, this would be support around and extra to a GP's capacity to refer to a gender identity clinic. Gender identity clinic waiting lists range from 9 months to 5 years, with 9 months being a real outlier at the bottom of that list. And so trans healthcare support extends a long way beyond a simple GIC referral, but even there, finding a GP who's willing to make a GIC referral can be particularly difficult. And we see this generally in more rural or isolated areas where GPs are unlikely to have come across trans patients before. This is compounded somewhat by issues within home office policy, or as we're about to discover on this side, a complete lack thereof. There is no specific policy regarding LGBTQI plus identity in accommodation with regards to who should be housed where and who with. The most obvious issue here is a lack of policy on how transgender men and women should be treated with regard to single-sex accommodation provision. But additionally to this, there is no policy for how people with non-binary gender identity or intersex individuals should be accommodated with regard to single-sex accommodation. And there's no specific policy addressing an increased risk for cisgender queer people that they might face from people of the same gender in single-sex accommodation. I apologize if you can hear an ice cream van going by my window. The other side of this is that similarly to the recent removal from detention policy, LGBTQI plus identity on its own is not considered a particular vulnerability when the Home Office is determining what constitutes appropriate accommodation. This means that you have a significantly increased requirement for evidence when arguing a person's vulnerability, which can be very hard to obtain based partly on what we discussed in the first slide, where someone might not have access to support from their GP, safety disclosing an incidence of harassment to their staff at the hotel, or support organizations who can substantiate their experiences. There's recently, last year now, been a change to the Home Office's standard of evidence for particular accommodation transfer requests, and a particular reliance on medical evidence, which can be really, really hard for queer and trans people to obtain. And that's seen a significant increase in transfer requests being refused for people suffering abuse and harassment where they've not had evidence to back up those claims and have just been relying on their own disclosures. With all of that being said, and if there's one thing that I would encourage people to take away from this, if it's nothing else, it's that with LGBTQI plus transfer requests, accommodation challenges, legal challenges, safeguarding concerns, and general requests of the Home Office, you are able to actually make significant headway and significant progress with the case, where you might not expect to, for other demographics claiming asylum or other people suffering problems in asylum accommodation. It can be difficult to do, but it is an area worth investing your time, because you do have a much higher likelihood of actually being successful. So I would greatly encourage anyone who is working with someone having a difficult time in accommodation for whatever reason to consider whether they are able to get considerations from the Home Office, because you are more likely to be successful than you might anticipate based on work with straight or other asylum seekers. One aspect of that is that the lack of policy can actually benefit your argument when advocating for your client. The fact that there isn't specific rules around what is and is not appropriate for LGBTQI plus individuals leaves a lot of scope for you to demonstrate vulnerability, but then make your own requests as to what would be appropriate for that person based on the evidence that you have. It can be difficult to obtain that evidence, but if you feel like you have that base, being creative and thinking about what you can actually ask for in the lack of policy can really improve your chances and improve your effectiveness in advocacy here. The lack of support for LGBTQI plus asylum seekers in a lot of areas of the UK, particularly surrounding more isolated Home Office accommodation sites, can also be really beneficial in making specific relocation requests. So it's relatively straightforward in many places to demonstrate that there is not community support or healthcare support for an individual, and that can allow you to request relocation to a particular area where you can evidence that support is available, which can obviously be more difficult to do for other asylum seeking populations. The other aspect of this, although it is hard to obtain, is that medical evidence for LGBTQI plus individuals can also be really, really effective. So sometimes where you have someone who is accommodated in single-sex accommodation that does not match the gender identity, a gender identity clinic referral from their GP, a letter from their GP, current or historic access to various aspects of medical transition, whether that would be surgery, hormone replacement therapy, all of that constitutes medical evidence. So being creative and thinking about where you get that can be really, really beneficial in making an effective claim for an individual. This also applies as well, obviously, to support letters or recommendations from therapeutic professionals, and also diagnoses and prescription for HIV plus individuals as well. The other thing I would like to touch on is how useful support letters can be for transfer requests and trying to resolve accommodation issues at a Home Office level. The one caveat that comes with this is trying to make sure that the support letters you are using, or the people who are going to for support, have a clear understanding of both LGBTQI plus issues, but also Home Office policy, and where they should be focusing their support letters in order to make them the most effective. This can be quite difficult, and I understand it's not at all times appropriate to request specific information from caseworking services or support organizations. But in general, you will often find refugee support organizations are unfamiliar or not confident in discussing or engaging with LGBTQI plus issues, and you'll find that LGBTQI plus organizations are not confident in their understanding of Home Office policy, what could be expected from accommodation, and where you might evidence vulnerability and need in order to make an effective support letter. So where possible, trying to make sure that the people you're going to for support letters are informed about what their support letter is for and what they should be focusing on is particularly effective. We also run trainings on this particular topic. So if that is something that your organization would like training on, again, please do get in touch on that. And then this I've fully just included because I like to put it everywhere just in case people aren't aware. This would be our go-to metric for what to do when raising issues for an LGBTQI plus individual in home office accommodation. So for non-safeguarding issues, your first step is to raise concerns with the welfare officer at accommodation if your client feels comfortable with you doing that and you deem it appropriate and not likely to impact their safety. If nothing's been done there, which it is quite likely nothing will be, contacting Outreach at Migrant Help or COC at Migrant Help and submitting as much supporting evidence as possible before escalating from that point, depending on what evidence you have and the situation for that person would be your steps. This is specifically not, by the way, going to cover where you might want to pursue legal challenge or submit pre-action paperwork. Again, that would be down to yourself or the solicitor you're referring to. In general, this is what a casework service would be helpful in doing in the run-up to a potential legal challenge around accommodation. So for non-safeguarding issues, you have quite limited recourse, which I'm sure everyone is really familiar with. Most of your cases will in some way fall into safeguarding issues where you actually have scope to properly challenge the Home Office's accommodation provision. And for this, there are a series of steps that are very helpful to run through and will also benefit a legal challenge if you run through them, as you then have a clear documentation of what the person has disclosed to you is the problem, and a clear lack of resolution provided by the Home Office channels, which will benefit anyone bringing legal challenge. So step one, again, contact the welfare officer if it's appropriate. At a level of severity, you will generally skip this step and immediately go to step two, where you would be contacting Migrant Help, Asylum Safeguarding, and then the accommodation provider safeguarding emails. I've included these here and the slides will be shared. So don't worry about screenshotting your page or anything. If no response is received within a reasonable time frame, and again, I would encourage you to set your own time frame on this based on the severity of what your client is experiencing and what can be expected from these services. But once you have reached that time frame, escalate that to escalations at Migrant Help. And if, and most likely when, you don't hear back from that, take that to G7 Asylum Support Escalations, which can only be done once you have followed steps 1, 2, and 3. If you've not done steps 1, 2, and 3, they're going to bounce you straight back and tell you it should be dealt with at a lower stage. G7 should respond within 3 working days, but again, you can set your own time frame on that depending on the urgency. Again, and I will try to wrap up because I think we're already at time, but just to touch very briefly on the recent Supreme Court judgment, as I'm aware that that looks like a particularly impactful piece of, particularly impactful ruling, particularly for trans people in home office accommodation. The good news and bad news here is that at the moment, I don't see it necessarily having a huge impact. The bad side of that is that if the Home Office does choose to write policy in the wake of this ruling, it's extremely likely that policy is going to negatively impact transgender individuals. I don't particularly want to comment on what that scope might be. I do think we will see a more difficult landscape in challenging accommodation for trans individuals in the wake of that judgment, just due to attitude in the Home Office and a boldness in disregarding the vulnerability of transgender individuals in general. However, in what is currently regularly argued in accommodation challenges and for legal challenges around home office accommodation for trans individuals, I don't believe there's a huge amount from the judgment that's immediately relevant absent of a change in home office policy. So very few transgender asylum seekers are accommodated in single-sex accommodation in line with their correct gender. where we see transgender asylum seekers in home office accommodation that's for single-sex individuals, we see it in the we see it primarily in the gender that is written on their identity document they use to enter the UK. And though there are some cases, I would find it really unlikely that you would find someone outside of an extremely successful challenge accommodating single-sex accommodation in line with their gender identity. There's also the factor that there are some trans individuals who feel comfortable in accommodation provision that doesn't match their gender identity. So working with trans men, for example, they may not particularly want to be in single-sex accommodation with cisgender men all the time, as the risk of being outed there might feel higher than being in a mixed gender accommodation or a women and families accommodation. This is true for both hotels and also dispersal accommodation, and it does happen more than you might think. So anytime that you are working with someone in that circumstance, make sure you're checking in with them about what they actually want from accommodation and not presuming that they inherently would want to be in single-sex spaces that align with their gender identity. A little bit of a complicated one, but always worth just checking in with that with your client and not making that presumption. And then the final and like most important one here is that when you are making requests from the Home Office for specific provision for trans asylum seekers, you are almost always arguing for single room or single occupancy accommodation in a specific location where they have access to a support network, and very, very rarely arguing that they need to be in shared single-sex accommodation. So for the arguments that legal representatives and caseworkers were already making, the impact of this judgment is not particularly relevant, as you're relying on a different part of the Equality Act that was reaffirmed and not adjusted by this ruling. I appreciate I've talked very, very fast, and I also tend to mumble, so I hope you've all been able to follow that. But that is also the end of the presentation.
Thank you, Ro. No, that was really brilliant, really helpful. I think it's always super helpful to provide actual email addresses to various Home Office departments.
This is where you contact them.
Yeah, and no, a super helpful overview of, you know, how people can actually advocate for LGBT people in asylum accommodation, both before legal proceedings become necessary, but also what can help to strengthen those legal proceedings and what we should actually be arguing for. So really great. Thank you so much to all of the speakers for all of your fantastic contributions. There's one comment just in relation to what Helen had raised about certified cases from Brazil, someone mentioning that the only case that they had refused for an application for indefinite leave to remain as a victim of domestic violence was for a gay man from Brazil. And that is going through administrative review now, but it's an interesting observation into the sort of parallels that we're seeing and how people are being treated. Potentially just, you know, initial thoughts are that we are seeing Brazilian people targeted for charter flights. So the sort of widespread removals that we're seeing, refusals that we're seeing, apologies, could be linked to that. And just seeing a couple of comments from people talking about how they struggle with Home Office policy, and also that people are not able to find legal aid solicitors at the moment, which of course something we've also addressed. But if anyone does have any other questions arising from this event, all of our information is available online. You can find out how to contact Rainbow Migration online. I will also just put in the chat box the website for Rainbow Migration, and you can also contact Garden Court Chambers, of course, if you wish to instruct us on any of these cases as well. So yeah, thank you so much for everyone for participating. I really appreciate it. And I hope you can all enjoy your Monday evenings now. So thank you very much.
Thank you. Bye.